Good morning, everybody. Welcome to the District of Columbia Court of Appeals. We have 3 cases on the calendar today. The first one is Richard Bennett versus United States. And Mr. Williams, counsel for Mr. Bennett, you may proceed.
Thank you, Your Honor. This is a case that highlights the structural right of self-representation. It's a deeply rooted right that it's described in Ferretta. It's described and it's reaffirmed in the case of McCoy versus Louisiana. It entitles a defendant to represent himself in order to ensure that the defenses he wants to present are in fact presented. It appears over the years that courts have conflated the idea of trial management and trial strategy, or trial strategy and choice of defense. Choice of defense is not part of trial strategy. Choice of defense is a fundamental right that exists that only the defendant has. There's no conflict where the defendant and counsel agree on the choice of defense, but there's a dispute about how to present it. That becomes a trial management issue, which is within the prerogative of counsel.
So
the trial court here conflated the two. And
it seems as though as part of trial management, one must discern whether the defendant is actually asking to represent themselves. And here it seems like every time the judge had that conversation with your client, he said that he didn't want to go on his own, and he agreed to having Mr. Viviani represent him either as attorney advisor or as his counsel.
Yes, after extended colloquies or extended discussions where Mr. Bennett would say to the judge, I want a new lawyer, or I don't want a new lawyer, I want to represent myself. I'm not happy with Mr. Viviani. And the judge, cognizant of Mr. Bennett's right to an effective representation, did everything he could to try to cajole and persuade Mr. Bennett to
I don't know that the judge did everything he could to persuade Mr. Bennett. I think what the judge did was reasonably probe what seemed to be a questionable choice mid-trial, particularly given that several months earlier, Mr. Bennett made quite clear that he didn't want to represent himself. He wanted Mr. Viviani as his counsel. And so I wonder why you say I wonder why you view it as sort of browbeating or bullying. It seems to me, in addition to having a right to represent yourself, you also have a right to counsel of your choice. And where Mr. Bennett is not at all clear which one he's asking for, at times is clear one direction and at times is clear in the other direction. I think you would agree with me that any good judge would want to make sure you've got his actual position before you decide how to proceed. And in this case, I don't view Mr. Bennett as being particularly steadfast in his demand for counsel. Do you disagree with that? I'm sorry, in his demand for self-representation.
I respectfully disagree. I wouldn't use the word bullying, or certainly I think the trial judge was very gentle, was appropriate in how he presented it, but it was not an appropriate topic. I would say that the proof that Mr. Bennett wanted to represent himself was the actions. Part of the proof is what happened before the trial, where he went through 8 different lawyers. At one point, he did survive there was a Ferretta inquiry where it was determined that he could represent himself. And then afterwards, when an attorney was appointed to advise him, Mr. Viviani, there was some balking at that point. And Judge Edelman made a point of saying, that's a good choice. So there was all kinds of encouragement. And I absolutely agree that it's appropriate for trial judges to tell a defendant who states an intent to represent himself, ask the "are you sure" question. But you can't go too far with that. And I would submit that as well-intentioned as the trial judge was, he went too far with it. by cajoling him and saying, rather than saying, no, you're going to have Mr. Viviani be your lawyer. You're going to behave appropriately. You're not going to get up here every 5 minutes and question him. He is your lawyer. He's doing a great job. Abide by him. That would be one thing. But by going wishy-washy, that's not a good legal term, but by the ambiguity and by trying to cajole him, Mr. Bennett, and trying to get him to change his mind, I would say that is an intrusion on, and I respectfully submit that is an intrusion on his right to self-representation.
Mr. Williams, one of the concerns I have is sympathy for the trial judge. Mr. Bennett was an unhappy camper, that's clear, but he seemed to change his mind every few hours. And he just didn't want to be in that situation of facing trial. And the arguments you're making suggest that there's no way for the trial judge to call that correctly, because we're going to second guess him under the right of defendant's right to determine the nature of his defense.
It's a tough call. I'm not going to dispute that, Your Honor. And yes, but the trial judge did go too far. It's just like the situation where a trial judge tells the defendant not to testify.
So when did he get far? Are you saying?
I'm sorry?
Which judge and when did the trial judge go too far? Are you saying that Judge Edelman went too far when he established that Bennett wanted Viviani to be his lawyer?
When he said good choice, I know it's tempting because of our jurisprudence in this jurisdiction in particular, where we honor and cherish the defendant's right to effective representation, and we do everything we can to ensure that defendants are ably represented. But this lost sight of developments in the law, particularly McCoy versus Louisiana, where Justice Ginsburg made a point of saying it's almost always ill-advised for a defendant to represent himself. But that is his right. And it's his right because he has the right to assert the defenses of his choice. Mr. Bennett made clear he had different defenses he wanted asserted. He wanted to assert the criminality of the police officer. Now, objectively speaking, is that a foolhardy defense? I don't think a trial judge would be wrong to say it is a foolhardy defense. But it is his right, Mr. Bennett's right, or anyone's right, to assert that defense.
And wasn't he permitted to assert that defense? It seems like they were asking questions in tandem to elicit both defenses.
They were a lot, and that goes to the other problem is it, rather than a decisive, you will be represented by Mr. Viviani, and we'll take our chances. If I am wrong, I'm wrong because of this structural error, the structural right to representation. Or I'm going to cast Mr. Viviani aside. You're on your own. It's something that's distasteful. I mean, we in this jurisdiction, as I said, frown upon. The whole idea is anathema to our jurisprudence of an individual representing himself, not having counsel. But Mr. Bennett had chosen that. He had made it clear by having 8 different lawyers. And yes, though he did get to ask some questions, it didn't go nearly as far as it would have if he had been representing himself. And Mr. Viviani made a point of saying logistically, I'm not asking these questions. And so if a jury sees that the lawyer is asking certain questions and refraining from other questions, that's bound to confuse the jury. And that undermines the structural right of self-representation. And I would respectfully submit that is what happened here. Now, if you view this in terms of harmless error, I concede that I lose because Mr. Viviani, in my opinion, did a great job. I think anyone could say he did a very good job under difficult circumstances. But the fact is, Mr. Bennett had a right, an absolute right to represent himself. And he was not given the opportunity to do so.
I mean, as I read if I recall correctly, the whole colloquy on July 7th comes up in the middle of the government's case. The government's putting on witnesses, so it's a question of, at this point, there's not a lot of defense strategy involved other than how do you cross-examine the witnesses. And when the trial judge says, in response to his request to self-represent himself, well, are you ready to proceed? He says, no, I need a day to prepare. This is a 3+ year old case at that point. He has gone back and forth on whether or not he wants to represent himself or not. And in addition to saying he needs a day to prepare, he also says, and also I'm not feeling well, I'm sick. He's not ready to go ahead, counsel. I mean, what is the trial judge? I take it you'd agree with me that the trial judge can take into account that he is not ready to proceed at that time and take into account an interest in avoiding that delay, right?
Absolutely. But one day is not a sufficiently significant delay.
Definitely not in the mine run of cases, but in a case where a defendant has changed their mind so many times, and what's going to happen the next day is he's going to assert he wants an attorney now. He wants Mr. Viviani back or a new attorney. I think a judge could reasonably anticipate that and say, you know what, Mr. Bennett, you can control your defense. You are in control. Mr. Viviani is just there for your utilization as you see fit, but he's going to sit at counsel table and as an advisor, and you can deploy him as you will. What's wrong with that? If I think consistent with what the trial court said, Mr. Bennett was free to tell Mr. Viviani, sit down. I don't want you to say a thing. Do you read the record differently?
I don't read the record differently, but I think there was some confusion there. And the safer point, the safer route and the appropriate route would have been to conduct a Feretta inquiry right then and there and tell Mr. Bennett, that's it. You are representing yourself. There will be no lawyer appointed for you. We are crossing the Rubicon with this decision. Proceed.
And so how do you square that with the July 11th transcript where the trial court has that inquiry, and he specifically says, and I think this is at page 20, he does not want to go on his own. That seems to be his moment of saying, don't cross the Rubicon. I want Mr. Viviani. And then even later that day, when Mr. Viviani is saying, hey, I don't like the situation, Bennett says he liked the way that it was going.
And I would submit that that's after cajoling and gentle persuasion by the trial judge as to what the trial judge perceived correctly to be in Mr. Bennett's best interests.
And what case do you have saying that gentle persuasion is not appropriate? Because it seems to me there are a host of federal cases that say the trial court actually has an obligation to warn a defendant that going on his own is potentially quite dangerous. And that you can say things, and I'm looking at some First and Sixth Circuit cases where your attorney's doing a good job, having him bow out now would be bad for you, it is absolutely warranted, which seems like the kind of conversations we have here.
Those cases predate McCoy, where the Supreme Court unequivocally reaffirmed or went a step further in its emphasis of the Feretta doctrine or the Feretta rule that self-representation is a deeply rooted right. I would draw an analogy to other issues where as I said, and it's in the brief, that the trial court cannot, there's certain realms, certain things that are exclusively within the defendant's province, certain things within the attorney's province. One of the matters within the defendant's province is the choice to plead guilty or go to trial, or to testify or not testify. And this court has spoken to the issue of a trial judge's persuasion, well-meaning persuasion, to try to talk a defendant out of testifying, and that was deemed an error. And I would submit that this falls within the same realm logically falls within the same views, because it's a structural right, just as the right to testify is.
Let me press you on that a little bit, Mr. Williams. The situation in McCoy was pretty dramatic. Do you admit your client's guilt against his wishes or not? I'm not sure that's at all comparable to what we have here. Do you have cases where our court or another court has applied the structural error analysis of McCoy to the type of situation we have here?
I do not.
All right, counsel, unless my colleagues have any further questions, well, you can take a brief moment to wrap up if you'd like, and then we'll hear from the government.
I would just say that I would respectfully request that the conviction be overturned and Mr. Bennett be afforded a new trial where he can represent himself, should he so choose, or he can represent himself. And I did not speak about the Frank's issue. I will let the brief speak for itself on that. And thank all three of you for allowing me to appear virtually at the last minute.
All right, thank you, counsel. We'll give you a couple minutes in rebuttal.
Thank you.
We'll hear from the government.
Thank you, Your Honor. Good morning, and may it please the court. Dan Lenners for the United States. There are a lot of things to respond to in what defense counsel said, but I'd like to start with one factual correction and then one legal correction. As a factual matter, the defendant made quite clear in April before Judge Edelman that he wanted Mr. Viviani to represent him. This is in the sealed record submitted by the defendant, in which the judge asked, "Do you want Mr. Viviani to take over as your lawyer in this case?" Mr. Bennett said yes. And then the judge said, "So you're asking that I appoint Mr. Viviani today?" Mr. Bennett said, "Please." So it's quite clear that in April, he wanted Mr. Viviani to represent him. And it was not until the middle of trial that he started making noises, primarily about firing Mr. Viviani and somewhat about representing himself, but never in any clear way.
So let's say we had a situation where April played out as it did, and then in the middle of trial, he says unequivocally, "I want to fire Mr. Viviani because I want to represent myself." What happens in that circumstance?
So there, the trial judge has discretion to deny that request. The law from both this court and the federal courts are clear that the absolute right for a defendant to proceed pro se once trial begins is now a qualified right, that the trial court has discretion to balance the prejudice to the defendant against other considerations, such as the administration of justice, in denying or in addressing that issue.
Right. I assume that discretion is not unfettered. One could abuse their discretion in making that determination. And the factors that should inform the trial court's decision, I take it, are, on the one hand, the right to self-representation is a constitutional right. It's important. Sure, it is curbed somewhat by it being mid-trial. And the counterweights are that the trial court should be taking into consideration are what? Confusion to the jury, unnecessary delay, things that, let me hear what you think they are.
The way this court set forth the test in Garrett in 1983 was the trial court must use its discretion and weigh the prejudice to the defendant against any problems of delay, disruption, and inconvenience to the trial.
And I think one thing that your opponent said was, well, there was not going to be a serious amount of delay if it was just one day. It's not totally clear to me what disruption to the trial means. I guess that to me kind of sounds like double counting the delay. I don't know what disruption there is other than the delay. And I forget the third one you listed.
Inconvenience to the trial. And I think those factors tend to take into account things such as the defendant's lack of knowledge of the rules of procedure and the rules of evidence. The fact that an uncounseled defendant may not be familiar with the discovery. For example, this defendant tried to cross-examine the government's chemist about a different chemist who had committed bad acts that had been produced in discovery, but was completely irrelevant to this case. And the trial court was very much focused on that when it considered Mr. Bennett's seeming request maybe to proceed pro se in some respect, and ensured that Mr. Viviani stayed on as in a hybrid role to be able to counsel Mr. Bennett about those procedural and other evidentiary issues.
In your view, does when the request to represent oneself come at trial also impact, perhaps if it's after the jury has been seated before opening arguments, and so there's potentially less disruption?
I think it does, Your Honor. This court has also found that the denial was not an abuse of discretion when it came at a critical stage during the trial. And I believe that was later on in the trial when it had proceeded and was closing to the end. And so when during trial would also be an appropriate consideration. I will point out that I litigated this issue in the DC Circuit, and I was unable to find a single federal case that found an abuse of discretion when a trial court denied a defendant's mid-trial request to proceed pro se. The federal courts at least have stated the abuse of discretion standard as considerable discretion, emphasizing how much control the trial court has over this decision when it comes to mid-trial, as opposed to pre-trial when the defendant does have an absolute right to represent himself. The legal error that Mr. Williams repeatedly makes is overreading McCoy. McCoy absolutely does not say that a defendant has the right to conduct his own defense in every way he wishes. McCoy quite clearly distinguished the strategic choices about how best to achieve a client's objectives versus choices about what the client's objectives in fact are. The defendant in that case did not want to having admitted to murdering family members. That is what his goals are, not about how best to achieve his goals, meaning how best to achieve his innocence. And there's a long line of Supreme Court cases, Gonzalez, Taylor versus Illinois, which say things like the lawyer has and must have full authority to manage the conduct of the trial. The adversary process could not function effectively if every tactical decision required client approval. That's from Taylor versus Illinois.
But isn't there an analogy to be drawn here? Because Mr. Bennett was trying to assert actual innocence, whereas Mr. Viviani's defense was the government had proven its case beyond a reasonable doubt.
I don't think that's a distinction without a difference. I think Mr. Bennett wanted to be acquitted. He said during the colloquy with the judge, I want to challenge everything. His was a scattershot approach to try to do everything possible to achieve his ultimate goal of being acquitted. And Mr. Viviani, as his counsel, had full authority to manage that strategy of acquittal and the way he thought best would achieve Mr. Bennett's goals. And so McCoy does not stand for the broad proposition that a defendant has absolute control over every strategic defense decision. To the contrary, it is a sort of sui generis case in the death penalty context involving a murder, which makes clear that when that defendants in that context may just have a different strategy. They may be willing to risk death versus life in jail, and so may make certain decisions such as the opprobrium that would flow from admitting that you murdered family members. They may never want to do that, even if it means that they will be convicted and sentenced to death. And so McCoy does not stand for the broad proposition that Mr. Williams has repeatedly attributed to it.
So it seems here like the trial judge was essentially trying to split the baby. So Viviani gets to make the arguments that he thinks are reasonable, and then Mr. Bennett gets to come in and say, the government planted all of this evidence, it's fabricated, yada, yada. Doesn't that sort of have the ultimate effect of actually weakening both defenses because it has the tendency to confuse the jury as to what really they should be focusing on?
It may, but that's Mr. Bennett's choice. the trial court bent over backwards to try to accommodate an incredibly difficult defendant who had fired 8 lawyers and was seeking mid-trial to fire a 9th. And so the trial court reached an accommodation where Mr. Viviani would examine witnesses, and then Mr. Bennett, if he chose, could then pursue his own cross-examination. Mr. Bennett didn't have to do that. He could have proceeded with Mr. Viviani entirely. He could have told Mr. Viviani, I don't want you to ask any questions, just advise me as this hybrid counsel. And so whatever negative effect it may have had on the defense was a result of Mr. Bennett's choices, not anything the trial court did. If there are no further questions, we'd ask that the judgment of the trial court be affirmed.
Thank you, counsel.
Thank you.
All right, Mr. Williams, we will give you just a couple of minutes in rebuttal. Mr. Williams, you're still on mute.
Sorry about that.
No problem.
I would point out that all the cases that are cited in the government's brief that talk about disruption and the discretion of the trial court to minimize such disruption predate McCoy. Also,
Can I just ask, do you take issue with the government's representation that the government says they've been unable to find a case, at least in the federal courts, where a court has found it to be an abuse of discretion not to grant somebody's request to represent themselves in the trial? Have you found any case that stands for that proposition?
I have not. And my argument to that is that that's pre-McCoy. McCoy changes the situation. And I agree that the facts in McCoy were far more compelling, but that doesn't alter the fact that McCoy, the Supreme Court did not say this is only for capital cases that this rule applies. They spoke at length, the Supreme Court did, about the structural right to self-defense. And so it's my position, and I respectfully submit the appropriate position, is that if there is disruption, and I'm going to concede that there will be some disruption, or there would have been disruption if Mr. Bennett had obtained a 1-day delay or a 1-day adjournment, that has to yield to a structural error, or a structural right, the preservation of a structural right, which was not as well enshrined in the thinking of the judges who addressed the issue prior to McCoy. I would also point out factually that it was after the Franks motion, before the testimony started, that Mr. Bennett made clear again reiterated his desire to proceed pro se. So I think what the government's trying to do is not so much dispute the structural right of self-representation, but to argue that the facts don't fall outside that. And I would submit respectfully that the facts support the notion that Mr. Bennett was seeking to represent himself, would have represented himself, but faced inappropriate cajoling and persuasion, very well intended by the trial judge, but nonetheless wrong, because it trampled on his structural right to self-representation and to present the defense of his choice, which was innocence, based in part on police criminality. And for that reason, I would ask this court to reverse the conviction. Thank you.
Thank you, counsel. I will take the case under advisement.
Very well.
Next on the calendar for today is 21 CV 354, CAROLYN GREENE versus Children's National Medical Center. We will hear from appellant. Is it Mr. Sure?
It is.
If you could just state your name for the record and how much time you would like for rebuttal. And then you may begin.
May it please the court, Peter Scher on behalf of the appellant CAROLYN GREENE. I would like to reserve 5 minutes rebuttal. We're here before the court as a result of the trial court's granting of summary judgment in the slip and fall case. Ms. Greene alleged that while at Children's Hospital on August 2nd, 2015, she slipped and fell as a result of streaks of moisture, a dangerous condition on the floor of a corridor. Ms. Greene alleged that that slip and fall occurred after a ride-on floor scrubber had passed through that same corridor, leaving these streaks of moisture. Now, the trial court found that the plaintiff, Ms. Greene, didn't sustain her burden of production because there was no establishment of notice to Children's National Medical Center. Ms. Greene would suggest that was error because in a slip and fall case, there are 2 different ways to establish negligence on the part of a property owner or occupier. First, by way of showing that the owner or occupier, him or herself, or through his or her agents or employees, created the dangerous condition. The second way is if a third party, such as a customer or another visitor, causes the defective condition, then actual or constructive notice is required. In this case, no notice is required because the allegation is that the Children's National Medical Center employees in the auto scrubber created the defective condition on which Ms. Greene slipped and fell.
And as I read the trial court's ruling, she also held that there was not sufficient evidence to survive summary judgment on that theory, that there wasn't evidence in the record that from which one might reasonably conclude that the slippery floor, if there was one, was caused by Mr. Parker, the floor scrubber. So do you want to talk about that?
Sure, yeah, so I was actually going to get into what we believe to be substantial evidence that the operator of the floor scrubber, Mr. Greene, is the person who left the streaks of moisture. Most important.
Mr. Scher, let me interrupt you initially. I apologize. One of the frustrating things I've found about this record is I haven't found any diagram or map showing the layout of the floors. Is there one in the record that is not in the appendix?
No, there are some photographs appended to the opposition to the motion.
No, I'm not talking about photographs. I'm talking about diagrams or maps that show, understand there's more corridors than what we see in the photographs.
Correct. There are no diagrams or maps of the location or the adjacent area to the location where the incident occurred.
Okay, I thank you for clarifying that, and please proceed with your answer to Judge Deal.
Thank you, Your Honor. So we believe there's substantial evidence, and I think the most important evidence is an admission on behalf of Children's National Medical Center that is set forth in Mr. Parker's supervisor's situation email report, which was prepared at the end of the shift that the supervisor worked. So just to be clear, there was one supervisor overseeing the floor cleaners that day. His name is Duke Nutsami. That's the name of the supervisor. At the end of Mr. Nutsami's shift at 12:16 a.m. on August 3rd, Mr. Nutsami wrote in an email situation report, "Today at about 10:30 a.m., I received a call from a nurse regarding one of the visitors that fell after the ride-on machine was used on 4 Main by N. Parker." 4 Main includes the corridor where the subject incident occurred. And from
But does 4 Main include other corridors in
It does.
addition to the one where she fell?
4 Main, as I understand it, is a unit. On that unit are multiple corridors, one of which is where Ms. Greene slipped and fell. But I don't know of any other slips and falls that occurred that day, and none has been suggested by Children's.
But
So
is that email from the supervisor admissible?
I think it is for multiple reasons. Number one, the nurse who called, nobody's disputing that that nurse is an agent or employee of Children's. Second, it's a business record. Third, it's an admission or at the very least, it's a statement of a party opponent. So I think for all those reasons, it's admissible. And Mr. Nutsomi did.
Does it purport to rely upon firsthand knowledge?
I don't think it's required to under, this court has adopted Rule 801 D2D. And I think the Federal Rule of Evidence 801 D2D. And I think that the case, that it's the Harris case, it's 834 A second 106, which is a case from this court in 2003. Personal knowledge isn't even required to make this an admission.
Isn't there a reliability component to the federal rule?
Actually, there's not. I think a close reading of the Harris case in the rule indicates because children's can put up their own personnel to rebut what's said in that email or to challenge it, that is not required. I don't think reliability is necessary.
Can I ask, just as a factual matter, did children raise a hearsay objection to the trial court considering that as evidence in the summary judgment stage?
No.
Okay.
No. And separate apart from that, Mr. Nutsomi at his deposition did adopt this statement as one that he had written. And I think a request for admission was put out, and children's admitted that this specific situation report email is genuine and it won't require authentication at trial. So I think everything's covered in that regard. I think it is admissible. Separate apart from that, there is additional evidence, including the fact that we've got streaks of the substantial evidence of this moisture came from the auto scrubber. Specifically, there's streaks of moisture across the hall, and the streaks of moisture run from behind where Ms. Greene slipped and fell to the nursing station where she was brought after the incident and where Ms. Greene saw this auto scrubber going by. Can
I just ask, there is one photograph in the record to Judge Fisher's earlier question about a diagram that I think I understand what's happening in the photograph, but maybe you could help me. It looks like it's taken from about the position of her grandson's room, looking at where she slipped and fell just before a couple of double doors. If I'm correct, just beyond, I don't know if there's only two photographs. One is of the door to her grandson's room and the other one is this one. So I assume you know the one I'm talking about. Am I correct? The X is sort of the spot where she fell. And if you go through the double doors, there's the nurse's station. Does that jive with your recollection?
Negative.
Negative. Okay. Well, then
Okay.
explain it to me.
So the photograph is taken from where Ms. Greene's grandson's room is. Ms. Greene would be walking away from the camera in that picture. There's an X where she slipped and fell. If one turns to the left, that's where the nursing station is.
Okay.
So it's not through the double doors. Ms. Greene's intent was to walk through the double doors to warm up her coffee. That never took place because she slipped and fell. But then the personnel from Children's assisted her to the nursing station, which would be to the left. So there's a corridor to the left at the double doors.
And so.
Mr. Sir, will you help me with this aspect of Ms. Greene's testimony? I think this appears in Joint Appendix 158. She's talking about seeing the machine on the hallway. Question, do you mean the hallway where you fell or a different location? Her answer, a different location. Next page of the Joint Appendix, she's asked whether she had ever seen, I assume she were referring to Mr. Parker, the man with the machine, in the hallway depicted in picture number 3. Her answer, I didn't see him there. So could you explain why that testimony from your own client doesn't defeat your inference that Mr. Parker put the moisture on the floor where she fell?
So if Ms. Greene had observed the floor scrubber in the hallway or the corridor where she fell, and she followed it, then I'd be facing a defense of assumption of the risk or contributory negligence. I don't think it's possible for Ms. Greene to have seen a moving device where she slipped and fell in advance thereof and not to have assumed a risk. That's not what we're dealing with here. We're dealing with a trail of moisture on the floor that went from behind where Ms. Greene slipped and fell to the nursing station where she was brought and where she observed the auto scrubber going by. The problem here is we're not dealing with this situation where it's a stationary, there's no stationary cause of the moisture. It's a moving cause.
But my assumption is that there's another hallway beyond the double doors. And it seems to me that the record is consistent with her having seen the machine operating in that, we'll call it a perpendicular corridor. But as she says, she never saw the machine in the hallway where she fell.
That is correct.
So I think you would be asking the jury to infer that if the machine was scrubbing that other hallway, the connecting hallway, then it must also have scrubbed the hallway where she fell. Is that correct?
That is correct, based on the fact that there was streaks of moisture from behind where Ms. Greene slipped and fell to the nursing station. Then we have this email situation report where a nurse who is yet to be identified and cannot be identified called and said Ms. Greene slipped and fell after N. Parker went by on the machine in a corridor in the unit where this occurred. Separate apart from that.
Sure what behind means. Does it mean back toward her grandson's room?
Exactly.
Or does it mean out by the elevators in a different corridor?
No, it means behind, meaning towards her grandson's room forward.
So how do we know that from the record you created?
Ms. Greene testified to it. And I think she even marked the photograph that Judge Deal alluded to earlier, where there's black pen marks leading up to the X.
And those black pen marks are the water or where she fell?
Yeah, it's where she saw moisture. And I'm speaking from memory. I'm not positive about that. I'm pretty confident that that's the case. So, but again, separate apart from the fact we've got this email situation report, we've got the streaks of moisture from behind Ms. Greene towards her grandson's room to the nursing station where this auto scrubber was observed. And then we've got Ms. Greene testifying that a housekeeper came out right after the incident and said, the floor's all wet, where are the signs? Now, I know that children's going to say, well, that's because Ms. Greene spilled her coffee there. I would suggest that there wouldn't be signs located up and down a hallway for a recently spilled cup of coffee. I would suggest the housekeeper would have gone and gotten a mop and cleaned it up.
Well, there's also, I mean, there are two other interesting facts about that I wonder if you might want to touch on. The email that seems to be recounting Mr. Parker saying that he didn't scrub in that area also says there is a sign nearby. Does he stick by that when he's deposed? Does he say there was a sign nearby, or I don't remember?
My recollection is he did stick by that, but he testified he didn't recall where he put the signs.
Mm-hmm.
And Ms. Greene said, I didn't see any signs. We have this housekeeper coming out and uttering, I don't see any signs. The floor's all wet. Where are the signs? So and then the question becomes, and this is according to a manager at Children's, why would you have up signs to do dry mopping? That's something you're not supposed to do, because then this caution signs become commonplace and people disregard them. And this is, again, a Children's National Medical Center environmental services manager who testified to that. So there'd be no reason to have signs up unless one was intending to or actually did auto scrub the floor.
Also, the second aspect of it that I find interesting, and maybe this is better to put to your opponent, was the statement was not just where are the signs they're supposed to be here. That's how Ms. Greene recounted it, which would seem to suggest she's not referencing a recent spill, but a pre-existing one. And I don't know if you've made any use of that, though. Does that strike you as important, that the statement is the signs are supposed to be here and not just where are the signs?
Well, I don't think anybody said the signs are supposed to be here. And I don't want to misstate the record. I think that the housekeeper came out and said, where are the signs? The floor is wet. Now, again, the environmental services manager, a gentleman named Randy Seidschlag, did testify that there'd be no reason to have caution signs up unless you were either preparing to or actually did conduct wet floor scrubbing
So
operations.
I just want to pause for a second because I'm going to read from her transcript from her deposition at Appendix 241. Ms. Greene said, she gives the where are the signs. She said, where are the signs that are supposed to be there? And then the question is, who did she ask? I don't know who she asked. She was like, where are the signs that should have been on the floor? I didn't see any signs. I do, I guess one way of reading that is that should be on the floor was Miss Greene's own gloss on the where are the signs, and she's just describing them. Another way of reading it is the statement was where are the signs that should have been on the floor. More literally, that's the statement that was given. So it sounds like you think it's the former. That's just where are the signs, and she's adding a gloss on it.
Or I didn't recall the record as Your Honor has it. So yeah, I don't want to discount what was said. So unless there's any further questions, I just ask that you all reverse the decision of the Superior Court, remanded for trial.
Thank you, counsel. We'll give you your time in rebuttal, and we will hear from appellee.
Good morning. My name is Crystal Deese, and I'm pleased to represent Children's National Medical Center before you this morning. We would ask you to affirm Judge Martini's grant of summary judgment in this case for the following reasons. Ms. Greene fell on Sunday, August the 2nd of 2015 on the 4th floor of Children's National Medical Center. She did not file suit until July 2nd of 2018. So she waited the fullness of the limitations period before she filed the lawsuit that would cause Children's to engage in discovery about this. And now comes and complains about what we were unable to find for her more than 3 years after her fall.
My recollection is that some of her injuries, some of the more severe aspects of it resulted, or I guess your position, because you're interpled, a surgeon, was they only arose later, which might explain why somebody might wait a while. It might not have seemed so bad if it was a broken wrist without any further injuries, but then more significant injuries cropped up, right?
Right. I believe she had her surgery in October of 2015. The fall was in August of 2015. And by the end of 2015, and certainly by early 2016, Ms. Greene knew she had what she believed was a permanent injury as a consequence of Dr. Azer's carpal tunnel surgery. The issue before your honors, the issue for you is speculation versus logical inference. That's really what the case came down to, I think, for Judge Martini. I have to say that the first argument used the word conflated, and I noted that Mr. Scher used the word in his brief. I want to say it was footnote 17, where he says that he conflated the law of owner-created hazards and third-party created hazards in his opposition brief, which goes back to your honor's question about didn't Judge Martini also find that there's no evidence that Mr. Parker created the hazard. So I just had to say the word conflated, and now I've done that. Judge Martini was correct in saying that to conclude the presence of a floor scrubber in a hallway after Ms. Greene fell in a different hallway, and that floor scrubber is what caused the fall, would require pure speculation. That's on page 12 of Judge Martini's order.
So can I ask about two facts in the record
Yes.
as to how well I think that is supported? Fact number one, and correct me if you think I'm wrong about this, but Ms. Greene testifies that in the spot where she fell, she sees long streaks in that hallway. When they ask her, and this is at page 245 of the appendix, when I got off the floor in the lower corridor, down in here, when they picked me up, the water was behind me. I looked back and you could see the water on the floor as she was going to the nurse's station. Fact number two, she has an expert who says, based on how she describes that, there's a high probability that came from a floor scrubber. Why isn't that alone? And I think there's some additional facts, but why aren't those two facts enough for a reasonable jury to infer, if they believe her and they believe her expert, that the water that she slipped on was caused by the floor scrubber?
Because, Your Honor, you cannot take those two facts in isolation. You have to take all of the facts that Ms. Greene testified to and all of the logical inferences from those facts. Granted, you must take them in the light most favorable to her, but you cannot isolate only those two facts. You have to add to it all of these other facts.
Okay, here's some additional facts. There's an email saying that Mr. Parker used the floor scrubber on the 4th floor main. Something that Mr. Parker unequivocally ends up denying. He says, I didn't use it on the 4th floor at all. I positioned it. That would seem to undermine his testimony somewhat. If he says, if the testimony is he used it on the 4th floor and he says, but not in that specific area, and then later in his deposition, he says, I didn't use it at all on the 4th floor, you've got contradictory statements.
But
One,
we don't have that.
okay, explain to me why not.
Mr. Parker only ever said, and Judge Martini's order makes clear, Mr. Parker was consistent and unequivocal. Over 5 times he testified, I did not use that.
Oh,
Moreover,
I understand that, but it's contrary to the email, which says he used the floor scrubber on the 4th floor main.
But what Mr. Niksomic's email says is after Parker moved, he doesn't say Parker caused the fall. He says contemporaneousn's exists. He does not say causation exists. Those two things are different.
I'm not sure. I'm not sure I follow. I guess I'm honing in on a very narrow point. Mr. Parker says, I didn't use that floor scrubber that day. Unequivocally, you tell me that. We have an email from what seems to be an agent of Children's saying the opposite. I received a call from a nurse regarding a visitor that fell after the ride-on machine was used on 4 Main by N. Parker. That's a contradiction, right?
It's an assumption that was never verified by anyone.
That's one reading of it. That doesn't sound like the light most favorable to Ms. Greene, though, to say that's an assumption that was made. This is somebody who's stating the floor scrubber was used on the 4th floor main by Ms. N. Parker.
The email is not admissible evidence, Your Honor.
Did you raise that objection at the summary judgment stage below?
Judge Martini didn't rely on the email because she recognized it was rank hearsay. If you look at the case of Pratt versus DC 407 A2D 612.
I had a simple question. Was an objection raised to it being considered?
I don't think he relied on it, so I didn't have to.
Okay. That's
And Judge Martini never considered it anything other than hearsay, as best I can tell, because all she said about it was Mr. Niksomic said, I did not investigate. Mr. Niksomic being the author of the email, he said, I didn't investigate. I just wrote down what they said. Did the nurse see the scrubber being used? I don't know how she could when Miss Greene herself says, I don't know if the scrubber brushes were up or down. I don't know how the nurse could say that when Miss Greene herself says, I did not ever hear the machine.
I mean, the nurse is out in the hallway, though, and she's in the room with her son. So, of course, a nurse might see it being used when she doesn't see it being used.
Miss Greene never put the scrubber machine in the area of her fall. Ever.
Yeah. Again, if she had, then you guys would have constructive note. You would say she was on notice that it was a dangerous condition. You know, again, the inference is if there are streaks of water that an expert says that sounds like it comes from a floor scrubber there on the floor. There's only one floor scrubber on the floor, on the 4th floor. Visitors aren't bringing floor scrubbers in. So it would have to be Children's who created that hazard. And do you agree with no, I mean, I see you shaking your head. So why is that wrong?
Sorry. What I would say, Your Honor, is Miss Greene walked up and down that same exact spot 4 times that morning. She was only not in that hallway for a maximum of 5 to 10 minutes by her own testimony.
How long do you think it takes the floor scrubber to get down get down a short hallway?
What I would suggest to you, Your Honor, is that is plaintiff's burden of proof, and they failed to meet it.
They needed to show that you could get it down a hallway in less than 10 minutes.
If they had given you evidence.
Did you suggest that it would take longer than that to make it down a short hallway?
You don't know that it's a short hallway because plaintiff's counsel didn't give you any pictures of the entire hallway, nor did he give you the diagram of the floor that we did indeed produce in discovery. Had he given you those things, you could have measured the distance and you could have made a determination as to whether that machine could get down that hallway. In the absence of that evidence, Your Honor, all you can do is speculate that that floor scrubber machine went from some hallway that you can't picture, that you don't know how far away it was because he didn't give it to you. All you can do is make a logical leap. to assume, as Miss Green did, that the first thing she saw when she got up, not noticing if her clothes were wet or not, the first thing she saw was a machine with a dude on it, and she's thinking, oh, that must be what caused my fall. Mr. Sir, are you?
Could you help clarify when Miss Green talks about she saw streaks behind her? Where is behind her? Where were the streaks located in relation to where she fell?
That is the plaintiff's burden of proof, Your Honor, and that matter in the record is not, there is no way a jury could find the streaks behind her lead to the water scrubbing, the floor scrubbing machine without speculating. Nothing puts the machine.
Help me with that. Assuming we read the record in the light most favorable to your opponent,
As you must.
what precludes us from thinking that a jury could find that the streaks were where she fell?
Because she never says the streaks run from me to the machine. Because she never says the distance between, because she never says the substance I fell in was the same substance that was in streaks in a different corridor. It's a different corridor. Ms. Green said, I don't know the color of what I fell in. I don't know what it was. I don't know how long it was down. She can't describe with any peculiarness where on the corridor she fell vis-a-vis the machine versus vis-a-vis the water. It requires a leap of logic to conclude that whatever substance she fell in is the same substance that she claims the machine was emitting.
It seems that it may become a crucial issue whether or not this email from Mr. Nsomi is admissible. I think we've established you did not object at the time of the deposition. Did you argue in your brief that it was not admissible?
I did not feel like I needed to argue in my brief that it was not admissible, Your Honor. This was a summary judgment motion, which comes before the motions in limine deadline. Had we reached the motions in limine deadline without winning summary judgment, I for sure would have objected to that. What I would say to Your Honor is Mr. Nsomi testified that he did not verify the truth of the statement. And even when asked in deposition, he said, I don't know what caused Ms. Green to fall. All the statement says is that there was a fall and it happened after someone saw Parker on the machine. And everyone assumes because he was on the machine, he was using the machine. Even if you give that to plaintiff, give her that inference, Your Honor. At the end of the day, what you're left with is a 5 to 10 minute window tops, a machine that her expert describes as making a loud noise, a loud vacuum noise. She never heard it. There's no indication from her evidence that she was deaf or that the door was closed. Merely helping your grandson with his breakfast is not going to make you unable to hear. And she never puts the machine in the area of the fall. And she never links the liquid that she fell in to being the same liquid that was streaking in a different part of the corridor.
I think it's that last step that I'm having a problem with when she has expert testimony that says it's a high probability that came from the machine.
But his testimony is based on the same speculation as her assumption, which is, I see water streaks over here. That must be what caused.
No, it's really not. He's not doing anything about linking it to the water streaks that are behind the machine. He says, based on the description of the streaks that she saw as being wide across the hallway, where she fell, I think, is the fairest reading of her testimony. Based on that description, I can't say I'm 100% certain, but it's a high probability that comes from the scrubbing machine. And so I come back to it again. What about that? Could a jury not reasonably credit her testimony plus that expert that comes from a water scrubbing machine?
I don't think so, Your Honor, because that expert was unable to say how long the water or liquid, whatever it was, would have remained on the floor before evaporating.
Who cares?
Because it's a 5 to 10 minute period and the machines are designed to only leave behind a thin film that evaporates within seconds.
I mean, they're designed if operated properly, right? I mean, I think part of the expert testimony is if not operated properly and they don't squeegee enough, they can leave streaks of water behind them. Or if they're just not operating properly.
There's no evidence of that, Judge Deal. That is sheer speculation that he.
The part about needing to squeegee the water up behind them?
The fact that he didn't do it, there's no evidence of that. There's no evidence the machine was malfunctioning.
Other than there being a lot of water on the floor that looks like it came from a scrubber. I mean, there's evidence of that.
In a different corridor, Your Honor.
Again, she says the streaks are behind her when she gets up and is taken through the double doors after her fall. I mean, she might be full of it. That might not be credible, but it's evidence that we have to assume a jury might credit, right?
I don't think so, Your Honor, because she did not hear the machine. She did not see the
Do
machine.
you think if somebody's
She
visiting
never-
with their sick grandson in the hospital and then sustains a traumatic fall, they might not have a recollection of every noise that went outside that door 5 minutes before the fall or a minute before the fall?
It's a loud vacuum type noise.
I
And she
don't-
believes it was the source of her fall. I think a credible assumption is that she would remember it. It's
I
equally.
don't know, it seems like a very easy thing to lie about. So, so far as it might even bolster her credibility for the jury that she's not saying that she heard it. And also, it's not entirely clear to me that in order to get to where she fell, it needed to go so close to her doorway. I mean, it's a slightly long hallway. So it might just be that it didn't go directly outside of it. And I don't really know what a loud vacuum means. It doesn't strike me that you necessarily need to be able to hear one 8 doors down. It just sounds like a lot of not charitable inferences at a procedural stage where we're required to make charitable inferences for Miss Greene.
I'm out of time. What I would say in response to that, Your Honor, is Ms. Greene's own testimony is why there are not more charitable inferences. We focused on a few things here, but what we haven't focused on is the fact that she doesn't know what she fell in. She didn't link it up to being the same substance that was on the floor in the pattern, according to her expert. And
I'm sorry, I really don't mean to take you past your time, but do you think most people know what substance comes out of a floor scrubber?
I think they could tell you the color. I think they could tell you if it was the orange juice that you were carrying with the waffle and the coffee that you just walked through the doorway with while your kid
She
was
just, I
on
mean,
the-
she describes it as
bicycle.
streaks of water, right? I mean, that's some description of the color. It was,
But I asked her specifically later, people use words colloquially to say water to mean liquid. I asked her, can you tell me the color? She said, no. I asked her, can you tell me what it is? She said, no. Ms. Greene did not know it was water, much in the same way she assumed Mr. Parker was using the machine because he was on it.
that's because, I mean, I have no idea what comes out of a floor scrubber. I wouldn't know what it is either. I've read this record pretty well. I have no clue. If it did come from a floor scrubber, I couldn't tell you what the substance was. And I wouldn't think, I don't know if you can, what comes out of the floor scrubber?
Cleaning liquid and water usually mixed together in some proportion. What could have been what Miss Greene fell on, though, Your Honor, will be my last point, is the orange juice, the coffee, the syrup that went with the waffle, all of which she was carrying in her hand while her young grandson, sick in the hospital, rode on a riding toy, spreading the mess that she spilled up and down the hall. That's as equally plausible as anything advanced by Mr. Scher. Thank you.
All right, counsel, you have 5 minutes for rebuttal.
The law in this jurisdiction is just not incumbent upon the non-moving party to rule out any other cause of the fall. It's simply to sustain a burden of production with the facts and the inference from those facts and license most favorable to the non-moving party, which is exactly what this email creates, exactly what these streaks of water going to the nursing station creates, exactly what seeing the auto scrubber come by the nursing station creates. It's exactly what the housekeeper coming out and saying, where are the signs, the floor is wet. All those facts and the inferences from those facts have created and established Ms. Greene's burden of production, I would suggest. So with that being said, the grant of summary judgment at this stage was inappropriate. With respect to Judge Fisher's question about behind, the streaks of water behind Ms. Greene, pages 245 and 250 of the appendix, there's Ms. Greene testified at her deposition. When she got up from the floor, she observed water to her rear on the corridor floor. That's from her deposition. Also, with respect to the streaks of moisture.
Let me stop you there. Depending on how she fell, the streaks might have been behind her beyond the double doors or behind her toward her grandson's room, correct?
I would agree with that, but I believe if you look at the photograph, the exhibit to the deposition transcript, it does reflect that the streaks of water were towards her son's or grandson's.
And you're relying upon a little circle, not far from the X that she placed there?
That plus her testimony that it was to her rear. She never made it to the double doors. She was almost at the double doors when she slipped and fell. So it would be unlikely that she's talking about to her front. I think she's talking about to her rear where she came from.
I guess we don't know whether the double doors were open or closed as they are in the picture.
That is correct, Your Honor. Also, in the appendix at page 243, Ms. Greene's testimony at deposition. At the nearby nurse's station, Ms. Greene observed, quote, a guy, end quote, on a machine, end quote. And the, quote, supervisor called him over to the desk and would speak to him about the floor being wet. Again, more evidence from Ms. Greene that the guy on the machine caused the floor being wet, hence the supervisor calling over.
I'm sorry, could you just give me the citation for that again? I just want to.
Sure, that's appendix 243.
Got it.
Ms. Greene's deposition at 62 line 5 through 62 line 21.
Okay.
Goes on. And this is appendix 244. At the time when Ms. Greene observed the man on the machine, quote, the machine was moving. It was cleaning the floor. He was on the machine cleaning the floor. That's Ms. Greene's deposition at page 67, line 16 through page 67, line 19. Again, more facts from which inferences can be drawn that machine was moving, it was cleaning the floor. And then it goes on to say, it was a lot of water on the floor behind him, right side of the hall. When I got up off the floor, you could still see water, streaks of water on the floor, and also some around the nurse's station. It was water.
Mr. Scher, I'm willing to agree that there's evidence that he was using the machine and was cleaning the floor. The question for me is which portion of the floor? And the trial judge thought it was a different part of the hallway.
That wasn't my read of the order. My read of the order was there was no notice. I don't know there was a significant question about the actual corridor, but it would be impossible, literally impossible for Ms. Greene to prove that the auto scrubber, the moving auto scrubber went through that corridor in that exact location where Ms. Greene slipped and fell without having a video, or unless Children's National Medical Center actually complied with the standard of care according to their own expert and kept logging records where they conducted wet floor cleaning operations, conducted investigations to what happened, and actually obtained the names of the supervisor at the nursing station, the nurse who called Mr. Nusami, the name of the housekeeper came out, the name of the other person who came to assist Ms. Greene. We don't have any of that information. And we've asked for it, but it was never produced because no investigation was conducted other than it sounds like Mr. Nusami came down and spoke with Mr. Parker, who denied ever operating this floor scrubber.
How do you respond to Ms. Deese's point that you're in part, maybe in large part, responsible for the lack of information because you waited nearly 3 years to file your complaint?
Well, to that point, and I think Judge Deal alluded to this earlier, Ms. Greene sustained a wrist injury for which she underwent carpal tunnel release. It was performed by Dr. Azer, who's a third-party defendant. As a result of that, she has something called complex regional pain syndrome, for which
I
she was.
understand that, but the lack of information is in part due to the delay in filing the complaint.
I disagree with Your Honor, and here's why. The standard of care, according to children's own expert, and by the way, Ms. Greene also adopted Mr. Froback, who's the expert, as her own after taking his deposition. He testified the standard of care is to immediately after an incident such as this, conduct an investigation, including photographing where the incident occurred, getting the witness names, determining what was on the floor where the person slipped and fell, and other things. None of this is done with Children's National Medical Center. And obviously, everybody knew that Ms. Greene had slipped and fallen because we've got this email. We've got Ms. Greene being taken to the emergency room at Children's National Medical Center. We've got the housekeeper coming out. There's nothing precluding them from having their security people, their risk manager, whoever it is, conduct an investigation. That they failed to do. It shouldn't be incumbent upon the injured party who's being taken out of the emergency room to conduct the investigation. According to their own expert, adopted by Ms. Greene, it's incumbent upon Children's National Medical Center to conduct an investigation. The fact they didn't do so is similar to the Genti case, the WMATA versus Genti case, where there was an issue with the door closing too fast on the injured party. WMATA didn't follow its own SOPs and conduct its own investigation. The court said, whoa, you can't use that against the injured party because you didn't comply with your own SOP. So I would liken this situation to the Genti case, Genty, where WMATA didn't follow its own SOP. In this case, Children's National Medical Center failed to comply with the national standard of care. And Mr. Roback testified it was national, that they were supposed to conduct an investigation, which they failed to do. I don't think that should be used against Ms. Greene. And I've gone well past my time. So with that, I'd ask you all reverse the trial court's decision. Thank you.
Thank you, counsel, for both sides. Take the case under advisement. We will now call our final case for today. It's 21 BG 743, in re Bryan A. Chapman. And why don't we hear first today from Mr. Chapman?
Good morning.
Mr. Chapman, if you can both state your name for the record and let us know how much time you'd like to reserve for rebuttal, if any.
Certainly. My name is Bryan Chapman. I'm the respondent, and I'll reserve 5 minutes.
All right, you may proceed.
Okay. This matter basically centers around a decision by U.S. District Court Judge Peter Massetti to dismiss a Title VI claim of a former client of mine who was a teacher in Prince George's County at Crossfield High School. What makes this situation somewhat unique is that Ms. Roberts, who is from the Virgin Islands, was working as a mathematics teacher at Crossland High School. She had been a teacher for, I believe, 40 years, had been working for Prince George's County Public Schools as a math teacher for 11 years. She had a master's degree and was working on her
Mr.
doctorate.
Chapman, we're familiar with the facts. I'd want to start you off with
Yes.
whether you waived the right to raise any arguments here by not filing exceptions before the board.
In fact, I did file exceptions, as I understood it. When the time came that I got notice that I had a right to file exceptions, in fact, I did. It was approximately a 70-page argument, very much covering the issues that are covered in respondent's brief. Essentially, the argument is that Title VI is separate.
And I'm sorry, do you happen to know where we might find what you're referencing as your objections to the hearing committee's recommendation?
It was not to the hearing committee directly.
No,
Even
I'm
the-
sorry. I mean submitted to the board, but taking objection to what the hearing committee recommended.
There was the exception 11 document that was filed, which is almost identical to the respondent's brief, except it ran about 70 pages.
Right, and so I'm looking at that, and I think it says it was filed in this court in December 2021. But
Yes.
the board resolved your matter in, I believe it was late 2021, before you filed these exceptions.
Yeah, I was unaware
October
of
2021.
I was unaware of procedure where I would file once again with them. What I had done is I'd filed a long document pointing out, I guess in response to their findings, saying essentially the same thing that also now appears in respondent's brief. And when I saw the recommendation, my conclusion was you simply ignored the law and you ignored the facts. So at that point, I
just want to be clear. So
Yeah.
did you file your exceptions before the board?
I don't believe it was before the board. I believe it was before this court. I was told that I had X amount of time to file exceptions.
Right.
And that's what I did. And that seemed to result in ultimately this process before the Court of Appeals.
So I think disciplinary counsel makes an argument that, we treat the board as something like an intermediate court of appellate review, with us being the court of last resort, that you start in the hearing committee, which is really the fact-finding body, and they make one recommendation, and then it goes to the board. And the board, in this case, I think, takes the hearing committee's recommendation and says, nobody's objecting to this. So we have, no reason to disagree with its conclusions. Mr. Chapman doesn't take any exception. The disciplinary council does not take any exception. So we will adopt this as our report and recommendation, and off we go to the Court of Appeals. And now that it's before us, one thing disciplinary counsel says is, look, if you wanted to take issue with what the hearing committee said, you had to take issue with it before the board. You couldn't just sit on your right to ask the board to review what the hearing committee said and recommended, and then wait to come to us. That's your chance for immediate review. And if you've bypassed that opportunity, well, then you've waived any right to come to us and complain about them adopting what the hearing committee said. So I think what we're asking is, do you have a response, either a factual one, yes, I did file something with the board, or a legal one, it shouldn't matter if I didn't file anything with the board. But what's your response to disciplinary counsel's argument that you've waived your objections that you're now bringing to us without bringing them to the board?
My response is that I responded in great detail to their findings. It was very similar, but longer than the respondent's brief that you have before you now.
So I'm sorry, I think we're getting confused here. So the hearing committee conducts its hearing, it
Yes.
issues its
Yes.
report and recommendation. Then under both the bar rules and the board's rules, both parties have 10 days to file exceptions with the board. The disciplinary counsel said they were not going to file exceptions. I presume they served that on you. The 10 days ran and you never filed anything.
I was unaware of that procedure that required me to file a response in 10 days. My feeling is that I had already responded with a lengthy document explaining in detail every aspect of my position, as well as my objections to the findings of the panel. So no, I was unaware that in 10 days I was expected to file exceptions. I thought I had already done that. It was only, I guess, once I got, I think, the recommendation. I inquired to find out what the procedure was. I actually came down to the Court of Appeals and was told that I had a certain amount of time to file Rule 11 exceptions. And that's the first time I was aware that I'd have an opportunity really to.
Would you agree it's on you to understand the proceedings, especially when these rules are available online and you could have called the bar to see what you needed to do?
Ultimately, I did that. ultimately I did contact, actually came down to the court to find out what the next procedure was. But there was nothing that I saw that I recall that said I had to respond within 10 days to I guess a recommendation at that stage that I had already responded to in a very lengthy fashion in great detail, a great amount of research.
And
so no,
so when you say I had already responded in great detail, what are you referring to? How did you respond in great detail?
What I received were findings of, I guess, Bar Council findings, and it was a lengthy document, point by point. And what I did is I responded to each point in great detail, very similar to.
Before what body? Was that before the hearing committee or the board?
That was probably the hearing committee. Because that was the finding.
They found against you in large part. And if I'm understanding correctly, you never challenged their findings before the board.
My impression at that time is that they completely ignored the law and the facts. And I'd gone through great length to make that very clear, what the facts were, what the laws were. This is a matter of the Title VI.
Let me give you a hypothetical.
Yeah.
You practice ostensibly in federal court, but that was the basis for these proceedings.
Yes.
So you have a case, someone files a motion to dismiss. You then have a certain amount of time in which to oppose it. If you fail to do so, a lot of courts would grant that motion as conceded. Then if it were to come up on appeal, we would say, you never put your opposition in below, so what are we supposed to do? And that seems to me to be quite the situation that we have here. The hearing committee disagreed with you. You failed to file exceptions as provided by the court or the board's rules. And now you're trying to bring these arguments anew without having the board have the opportunity to consider them.
I don't think that should apply in this situation. And the reason why is because I did take a look at the rules. I did see that there were these Rule 11 exceptions. And I immediately went about preparing a brief. It ran literally 70 pages, and it was repeated the information that I put into opposing the findings.
Here, but there's a three-step process. It's hearing committee, which I understand you did make your case before.
Yes.
Then it goes to the board, and you had 10 days to file exceptions, and you didn't. And the rule is quite clear that if no exceptions are filed, the board shall decide the matter on the basis of the hearing committee record, which it did. And now they're arguing, great, you filed these 70 pages of exceptions in the DC Court of Appeals, but that's too late because you never contested any of this before the board itself. So what is your argument to why that shouldn't be a forfeiture that we hold you to? My
argument is that I made every argument that I'm making now when I responded to the findings.
Disciplinary counsel's proposed findings.
So
it's sort of, you made your argument to the hearing committee. All of that is sort of part of the record that gets transmitted to the board, and they should have fairly read that as continuing objections, despite the rules saying that you need to file specific exceptions with the board to the hearing committee's report. You say, it's all clear enough. I take it to be roughly your answer. It was all clear what I was complaining about. And they had reasonable notice of it, despite me not filing specific exceptions before the board. I've done it before the committee, the hearing committee. I did it before you guys. Who needs the board, kind of?
Well, my feeling is this all merges. It's a process. It's not clear to me at which time, when it's in the jurisdiction of the Bar Council or Discipline Council, and when it's in the Board of Professional Responsibilities, and when it's in the Court of Appeals. I did not receive notice that I recall that I had 10 days to respond to the recommendation. I felt as though I'd spent quite some time responding to the findings. And when I looked at the recommendation, I felt as though they were completely ignored. There's no citing of cases or anything like that, or citing of any relevant facts. They just know we're just not going to.
And it seems that the board is arguing now that your objection, all the things that you're saying now, you should have made to the board. And I'm just wondering what would excuse that forfeiture?
Well, I believe that the Rule 11 exceptions, which I was told contact bar counsel about that, which is what I did. Then also I took a look at rules that are provided by bar counsel. And I did what those rules instructed me to do. I actually came down to the Court of Appeals and confirmed this is what you're supposed to do. So to say there's a difference between process before discipline council, process before the committee, process between the Board of Professional Responsibility, and the process here at the Court of Appeals, to me, they're all merged. I've said consistently the same thing. And where I've seen a rule saying that I have to respond, I have responded with great length. And I've made the same arguments time and time again. So, when I look at the recommendation, my response is, you didn't even consider the law. You've just simply gone ahead and said, we're going to find against this guy because that's the thing to do. And to me, I felt, finally, when I got to the Court of Appeals, I felt maybe I was submitting something to someone who's going to look at the law and look at the facts. And that's why I don't think this process with whether it's the board, exceptions in 10 days should apply. Simply because they weren't looking at the law and they weren't looking at the applicable facts. They're simply saying this guy is objecting to what we've said. We're going to recommend against him. And that's where I feel the problem is.
Mr. Chapman, I've looked, but I haven't been able to find. Did you ever appeal Judge Massitti's ruling to the Fourth Circuit?
No, in fact, I did not. One of the problems was that.
So we're in an awkward situation here. You didn't go to the body that has the authority to say that Judge Massitti was wrong. And it seems to me you're asking us to rule that he got it wrong. Is that essentially what you're doing?
At the time that Judge Massitti issued a decision saying that Title VI did apply and that he denied the motions to dismiss of the school board, at that point, it was still very murky. Title VI is just not something, even you read Judge Massitti's opinion on that, it takes time to really understand how he's agreeing with you. And as I had several other clients, under the same claim. And no, I did.
Let me ask you to respond to my question.
Yes.
You're actually asking us to rule that Judge Massitti got it wrong, correct?
That he had even admitted that he got it wrong 5 months later. That's not the primary thing here. I'm just saying that to suggest that I did something wrong is what I'm saying. As far, it's clear to me.
Where did he admit that he got it wrong?
The case is Sally Rogers versus Board of Education of Prince George's County. It is in fact mentioned in all of the briefs that I submitted. And what the judge essentially said is that in order to bring a Title VI claim, the complaint need only state that the employer received federal funds for the purpose of employment. And that's the key to surviving a motion to dismiss on the pleadings of a complaint. And Judge Massitti, 5 months later, wrote up that brief and said that, and other judges in the Maryland District's court have repeated what Judge Massitti said. It just simply means that the complaint has this language in it. But he did not say that at the time he dismissed Ms. Roberts' complaint. He simply focused on Title VII, which admittedly Ms. Rogers did not meet the deadline for that, and said nothing about the Title VI claim, which is what felt at the time was the real viable claim going forward.
Mr. Chapman, your time is up, but we kept you occupied with a waiver conversation for quite a while. So if you want to take just 1 or 2 minutes to talk about why you think your argument was the correct one in Judge Massitti's case, We'll give you just a little bit of time to do that before we hear from disciplinary counsel.
Thank you. Thank you. Should I begin now?
Yes, please.
Title VII is the conventional route that an employee takes when complaining that the employer is discriminating against them on the basis of race, sex, national origin, religion. And probably 99.9% of discrimination complaints are done through Title VII, where a complaint is filed with the EEOC or a comparable state or local agency. Administrative exhaustion takes place, usually over a period of 6 months. And after that period of time, the EEOC may issue what's called a right to sue letter, which gives you a right to go into federal court.
And you brought this claim without having had your client exhaust those administrative remedies, correct?
Exactly. There was acknowledgement from the very first meeting that you could not go forward under Title VII if you had not filed a complaint with the EEOC. And the situation is when she went with me in 2010, she was talking about something that began in 2005, 2006. And it was just very obvious that, 5-6 years go by, you cannot go Title VII. I didn't take her case initially, but she called me back maybe 3 weeks later. And by that point, I learned quite a bit about Title VI. Title VI became relevant because the school system a year earlier was talking about, we got all this money for
But you
jobs.
still raised a Title VII claim, and you've now just said you knew it was baseless when you filed it.
Because on April of 2011, Judge Massetti held a hearing. And at that point, all of these cases were in one single case called the Johnson complaint. And what he did is he dismissed the Johnson complaint. He said, all of you are going to file separate complaints, and you're going to file a complaint with EEOC. And the only way you're going to go forward in my court is through Title VII. So therefore, in filing a new complaint for Ms. Roberts, I knew that this judge had said, the only way you're going to go forward in this court is by filing under Title VII. But I also knew that the real avenue for going forward was Title VI.
So you're saying that you think Judge Massetti invited you to file a baseless claim, so you did?
Well, he told everybody
He
to
said
file
your
under
only-
Title VII.
your only
Yes.
route is Title VII. At that point, the onus was on you to tell your client, I'm sorry, your Title VII claim is untimely and you did not exhaust your administrative remedies. So I can't in good faith file a baseless complaint before this court.
That conversation was had with her at the initial meeting. And in fact, the meeting ended and I didn't represent
She
her.
didn't file a baseless complaint. You did on her behalf.
Well, no, I always knew Title VI was the way to go. But I needed more time to investigate Title VI. Title VI is a little complicated before I was going to file Title VI. But Title VI was clearly the avenue. She gave me a lot of information about meetings with the school superintendents, 2 of them, complaining to the union. They filed a grievance, hiring a lawyer who wrote saying, she's being treated unfairly. So they knew about her situation for years. The other thing is that several, teachers contacted me. They were foreign teachers from areas like Africa, the Caribbean, South America, and the Philippines. And they said, we're being discriminated against. They're questioning our immigration status. And later on, in April of 2011, the Department of Labor issued a press release saying that Prince George's County Public Schools mistreated foreign teachers. The Post picked up on that, said that the school system owed foreign teachers millions of dollars. They published another article talking about how they were being treated differently. And then finally, within, I think, the same month, Department of Labor issued a press release saying that Prince George's County was a willful violator because it intentionally violated labor laws concerning these foreign teachers. So when you put all of that together, Ms. Roberts' complaint, you're hearing from teachers, you're then reading this from the Department of Labor, and these are appearing in the Post. you kind of realize there's something there in terms of discrimination against these foreign teachers. And Title VI applies because at the same time, the school system was receiving federal funds under the American Recovery and Reinvestment Act of 2009 to stop the layoff of teachers.
But your
Okay.
Title VI claim was also time barred.
No, it's not time barred in the sense of you'd say you have X amount. There's a 3-year statute of limitation, but it really applies during the period of time the money is being received. The money, from the American Recovery and Reinvestment Act began in 2009, spring of 2009, and it ended in 2012. So during this period of time when this lawsuit was filed, Title VI applied. And another thing that happens here is Title VI is not about responding at superior. It's not based on the misconduct per se of the principals. It's rather on the school system. Did they have actual knowledge? And in having actual knowledge, did they take actual measures to investigate or corrective action? That if they don't, then that's deliberate indifference. That's what you need to do to establish a Title VI claim. And in fact, one of my clients, John Everhart, went to trial on Title VI. He's part of the group. He was awarded $350,000, and Judge Massetti later awarded him $200,000 in back pay and benefits.
Okay.
So, and he went to the Court of Appeals, and they approved it. So
Thank you, Mr. Chapman.
Sure.
We were taking you well over your time. I don't want to cut off any questioning if my colleagues have any additional questions, but otherwise we will give you a few minutes for rebuttal and we will hear from disciplinary counsel.
great, thank you.
Thank you, Your Honors. My name is Miles Link. I'm representing the Office of Disciplinary Counsel. Mr. Chapman has made a number of statements today that were new to us. We have never seen the 70-page document he claims he filed with the court. We were never served with this document. We have no idea what was in the document. What we do know is that he never filed exceptions with the board to the hearing committee's report and recommendation. What's more, as this court
The
knows.
document he's talking about was filed in this case in the 21 VG 743.
If what he's talking about are his objections to the proposed findings of fact of the Office of Disciplinary Counsel, is that what we're talking? So, okay, so now we see where we are. We've now clarified what was unclear from his statements. He was not objecting to the hearing committee's report. He was objecting to the proposed findings of fact of the Office of Disciplinary Counsel. That's a completely different thing. He never filed an objection to the hearing committee's report with the board. Remember, we are dealing with a lawyer, not a layperson. The idea that a lawyer in the midst of a disciplinary proceeding did not read the board rules, particularly rules 13.4 and 13.5, to understand when he had to file. And remember, when hearing committee reports are sent to the parties, the executive attorney of the Board of Professional Responsibility encloses them with a letter. And his letter tells people if they have objections, if they want to take exceptions, how to do it.
So I take the point that he did not file exceptions for the board. I feel like we've gotten to the bottom of that, but the board's rules nor the disciplinary rules suggest that there is a forfeiture consequence that flows from that. So it merely says that if someone does not file exceptions, I believe that you just take it on the record before the hearing committee. So how do you get from that to a straight forfeiture in this court?
Thank you, Your Honor. This court has held in In re Abrams that a party who fails to raise an argument before the board waives that argument before this court. Here, he failed to raise any argument before the board. Therefore, he waives those arguments before the court.
And how do you square that with the Johnson case, which is a case where I think the same thing happened? Well, I guess slightly different. There, you and the respondent filed exceptions, then withdrew them, and the board, I think, had similar language to what it did here, which is it was just deciding it on the record. And we held that he had not forfeited arguments here so far as they've been preserved before the hearing committee.
Because as Your Honor pointed out, exceptions were taken in that case. They were filed. Yes, they were withdrawn, but it was clear that respondent was taking objections in that case. Another case along those.
That seems crazy to me.
No, respondent had filed, taken in exceptions. respondent and disciplinary counsel may have withdrawn their exceptions, and then respondent filed his appeal with the court. But it was.
Can I just ask factually, do we know, I mean, it would be one thing if they said, look, board, we don't want to drag this thing out. We know where this is going. This is going to go up to the Court of Appeals. So forget our exceptions here. This is a purely legal matter. We don't really need you to resolve this. We'll withdraw our objections. We're going to take it up to the Court of Appeals. That would be a record in which we might say, okay, well, that's, they've fairly preserved their exceptions. Do you know what the record looked like in Johnson? Because it strikes me as quite bizarre. Filed exceptions, withdrawn exceptions. That sure sounds a lot like not filing exceptions at all to me.
So I don't know whether or not the respondent in Johnson made that kind of claim to the court. But what we do know, and what distinguishes that case from this case and makes that case more like In re Abbey, is that exceptions were filed. They were withdrawn, but they were filed with the board. And In re Abbey, the respondent took an exception with the board, but did not file a brief, and therefore waived the right to oral argument before the board. And the court nonetheless said they had filed exceptions with the board. You waived your right before oral argument with the board, but you have not waived your right to come before this court. Why is that important? Because the board has before it a statement of what exceptions a party takes to the hearing committee's report and recommendation. And the board can then consider those. The party may not file a brief, the party may not oral argue, but the court now is seized with the knowledge that there have been exceptions, and it can review the hearing committee's report in the light of those exceptions. In this case, the board report is all of 2 pages. The board adopted the hearing committee's report and it incorporated it by reference. The only issue before the board was whether the hearing committee report was supported by substantial evidence in the record. And it clearly was. Without any exceptions taken, this court does not have the benefit of the board's determination and consideration and report to you, which this court generally gives some deference to the board's report. If we allow this to go forward, in this case, you are creating a precedent, and you're creating a plan B. I can take my exception to the board and argue before the board, or just file an exception with the board. That's plan A. Or plan B, I don't need to do that. I can bypass the board entirely and I can come to the Court of Appeals.
I don't think we'd be holding that. It seems like in 2017, this court already held that in the Johnson case.
Well, but you see, in the Johnson case, it was known to the court, it was known to the board, and it was known to disciplinary counsel as a party in the proceeding that the respondent did have an objection, did file exceptions in that case.
Is a withdrawn objection an objection? I mean, I don't mean to get too theoretical with you, but there was no objection at the time.
Your Honor, if I were arguing that case here, I would argue a withdrawn objection is no objection.
But do
You
you
did argue that.
Yeah.
We disagreed with you.
I'm sorry?
You did argue that in Johnson.
Yes.
We disagreed with you.
Yes, you did. And therefore, and so you found that a withdrawn objection was an objection.
Withdrawn objection was not an objection, and we said it didn't matter. We said ordinarily people should raise their arguments before the board, but we then proceeded to address the merit.
But here you have no objection filed whatsoever. There you could make the argument that a withdrawn objection is not relevant and you can hear it, but you have before you, as the board had before it, the fact of an objection. Here we have none of that. We have an allegation that an opposition to proposed findings of fact at the hearing committee level filed with the court somehow is sufficient to state arguments that were never presented to the board and which are now being presented to this court. We submit that's a different factual predicate, and we submit that that should not be allowed to proceed. Otherwise, you're opening the door to a systemic alternative to the disciplinary process that this court has created through the intermediate appellate process of the Board of Professional Responsibility. And you're denying to yourself the benefit of the board's consideration of respondents' exceptions.
So I, to your friend on the other side, noted a hypothetical where, under certain local rules in federal court, if you fail to respond to or oppose a motion to dismiss, it can be granted as uncontested. Would it be within your power to promulgate rules saying that you must file objections before the board within 10 days and that a failure to do so would constitute a forfeiture if we think that the rules as they currently stand are unclear?
Well, it would not be within our, as Office of Disciplinary Counsel would not have the authority to promulgate any rules of the board. We think the board could not promulgate rules that bound this court. The board's rules bind the board. And so 13.5 says if you haven't filed exceptions before the board, we will deem that you're taking no exceptions. This court.
That's not what you say. You say we'll review the record that was before the hearing committee. You don't
That's
say
right.
we will deem that you are not challenging anything.
I'm sorry?
You don't say that you will, that the rules don't say that the board will have deemed this to be not challenged or not opposed.
The board's report did indicate that the board, no exceptions were filed by either party, and therefore the board took the hearing committee's report, and the issue before the board was whether the hearing committee's report was supported by substantial evidence in the record. It did not, there were no exceptions to consider, and so the board did not consider them.
Mr. Link, is there a distinction to be drawn here between findings of fact and conclusions of law? It seems to me it may be more important for the board to be told that the findings of fact are clearly erroneous than for the board to be told that the legal conclusions are wrong.
Well, there always are distinctions between findings of fact and conclusions of law. The hearing committee is the primary fact finder. It sits to hear the evidence. It heard the evidence. It determined the credibility of the witnesses, and it made the initial findings of fact, which the board accepted in total and included by inference and reference in its report. Conclusions of law, the board has the authority to consider de novo the conclusions of law reached by the hearing committee. The board, in this case, let's assume that it did so. In its report, it found no reason to disagree with the hearing committee, and it adopted the hearing committee's conclusions of law as to the violations found in this case in toto. And so on the record of this case, the board determined there were no factual or legal infirmities to the hearing committee's report and recommendation. Again, this points out how important and taking an exception is, because an exception would refer the board to certain findings or certain conclusions of law, which the board might then scrub with additional ferocity to see whether or not there was some infirmity there. Here, there was no allegation of any infirmity in any finding or any conclusion, and the board therefore looked at it to see in terms of, was there substantial evidence in the record? Remember, the standard of substantial evidence isn't that I agree with what the lower court or the administrative body found, just was there substantial evidence in the record to support what it found? And the board determined that there was.
All right, Councilman, do you want to say anything as to Mr. Chapman's Title VI argument on the merits, or do you want to rely on waiver alone?
I don't want to rely on waiver alone. I do want to point out that the Title VI claim, the district respondent is essentially collaterally attacking the district court's decision in this forum. As respondent admitted, he did not appeal it, nor did he ask the district judge to reconsider it. We shouldn't, in the previous two cases, the word conflate came up. I'll use it now. We shouldn't conflate this individual case with the other cases the respondent had, and he referenced one of them where a Title VI claim was sustained. Title VI deals with racial discrimination. That other case dealt with a white plaintiff who claimed discrimination by African-American Black supervisors. This was not a case of racial discrimination. This was a case of national origin discrimination, and Title VI does not apply. Title VI, there is no basis in Title VI for
Is it
national
really
origin
a
discrimination.
collateral attack on the district court's judgment, though, when in fact all he needs to show is, look, maybe I'm wrong. I know he's trying to say more than that. He's trying to say he's right, but he could say maybe I'm wrong, but I'm not incompetent, and it wasn't frivolous to say that a claim could have arose under Title VI. That's all he needs that's all he needs to establish, right? And so I guess, what's your argument that it was a frivolous or incompetent thing for him to raise?
First of all, he raised Title VII, he raised Title VI, he raised 1981. Those claims were either time barred, or the statutes he was relying on did not apply to the kinds of evidence his client could present, or there was no factual predicate to support the arguments. That is to say, he had not, for example, alleged discrimination to the school board. His client hadn't advised the school board that she was claiming national origin discrimination before she sued the school board for national origin discrimination. The allegation that all you need to show for a Title VI to establish a prima facie case for a Title VI claim is that the respondent is receiving federal funds, that's, with respect, ridiculous. You have to, Title VI isn't about who's paying your funding. The Title VI is about whether or not there's been racial discrimination. And so funding only gets you to this party might be liable, and now, or have you alleged racial discrimination?
So in the few seconds you have remaining, I just have a quick question as to why this took 9 years between the filing of the complaint and disciplinary counsel's process starting.
Your Honor, that's a fair question. I don't know that I can answer that. That took place before I joined the office. We have a number of cases. This case was being investigated, as other cases are. Respondent, I don't believe, was prejudiced by any delay. The complainant was able to testify before the hearing committee. The hearing committee was able to have all the evidence it required before it. So again, I think that's a fair question, and we try to expedite our cases as quickly as possible. And sometimes as quickly as possible means longer than you would like. And this might be one of those cases.
Let me ask you, Mr. Link, about the harm to the client. It seems to me there are two kinds of harm: aggravation and a waste of her money and paying attorney fees. I did not see in your request for relief any request that we order Mr. Chapman to repay her attorney fees. Have I missed something?
Your Honor, that is an excellent question. And we did not take an exception to the recommendation of the hearing committee, so I am not in a position, therefore, now to do what respondent is doing and arguing before you to take a different position. But this court has within it the discretion to order just the kind of relief you've identified, and the court can do that on its own motion. I will note that when the district judge, the complainant, Ms. Roberts, testified, she was in the federal court when the judge said, this case doesn't belong here. You have no claim. And it was traumatic. She had been led to believe over a number of years by respondent that this was a good case. She had a good claim. She's going to recover. And the judge threw it out and dismissed it with prejudice. I think this complainant suffered. And I do think if this court were to order that her legal fees be refunded, that would be an appropriate order for this court to make.
Thank you, counsel.
Thank you.
There are no further questions from my colleagues. We will give Mr. Chapman the final few minutes of rebuttal.
Well, the first thing I would say, my impression from the recommendation and all communication I had with the committee and with the Board of Professional Responsibility is that no one took any consideration or even maybe read the case law surrounding Title VI, 1981, or even what establishes a prima facie case of national origin discrimination. There's no reference to cases. On the other hand, what I wrote and what I've submitted on all occasions have been packed with case law, multiple cases cited from the Supreme Court to the Fourth Circuit to other courts that justify. Nothing is my own opinion. One of the things
What
that
is your case that 1981 allows a claim for national origin discrimination when the plain text limits it to race?
that is based on race discrimination. That was against the Prince George's County Educators Association. That's the teachers union. Miss Roberts is Black. She was born in the Virgin Islands, but she is Black. And the original complaint, the Johnson complaint, had several women who were Black who said that when they approached the school union about filing a grievance, race was one of them, retaliation, and in Miss Roberts' case, national origin discrimination, this occurred in 2009. And it was at a time when, 2009, the year lawsuit was filed a year later, they would not even give them a grievance form. That's what several of these women said. They were all Black. So was it national origin? No, some of these women were born right here in the United States. So when Judge Massetti said, 1981 does not apply because you're alleging national origin discrimination, not at all. The complaint said this is a Black woman. The Johnson complaint cited several Black women who said when we approached the school board about filing a grievance, they would not even allow us to give us a grievance. And most of this occurred right around 2009, 2010. So it wasn't an issue of statute of limitations. As far as Title VI is concerned, Title VI covers two types of discrimination: race discrimination and national origin discrimination. So bringing a Title VI claim for national origin discrimination is just as valid as bringing a claim for race discrimination. The statute states those two situations where the law applies, race and national origin. Would have been a different situation had been alleging sex discrimination or disability discrimination or something like that. But it's very clear, national origin and race. As far as my impression, essentially, when I got the recommendation, I said, where are all the cases that I cited? Where is, something referring to Title VI? Where's something referring to Judge Massetti's opinion in Sally Rogers versus Board of Education of Prince George's County? That case today is cited by the Justice Department. If you look at the Justice Department Title VI manual, that essentially says that an employee has a right, a private action when their employer is receiving federal funds, and those federal funds are particularly for employment. That's what the American Recovery and Reinvestment Act of 2009 was about. So, if you look at, for instance, Supreme
Mr.
Court,
Chapman, you are over your time. If you want to just take a couple of sentences to wrap up,
Yes.
you may.
As far as establishing a private right of action, one need only look at Barnes versus Gorman, Supreme Court case. Barnes versus Gorman cites Alexander versus Sandoval. And both those established that an individual can bring a cause of action under Title VI for race or national origin discrimination. The other thing is simply that there's no requirement for administrative exhaustion. That can be found at Fitzgerald, another Supreme Court case, versus Barnstaff.
Thank you, Mr. Chapman. We appreciate it.
Thank you.
All right, we have your argument. The cases will be submitted and this court is adjourned.